Case 24-1622 Citizens Property Insurance Corporation v. Melinda Looney and Robert Lynn. I'll give counsel a few moments to collect their things. All right, counsel for appellant, please introduce yourself and let me know how much time you want for rebuttal.
May it please the court, Drew Peeler. I'd like to reserve 6 minutes for rebuttal, please. Your Honor, Citizens is entitled to remittitor in this case because the jury's finding that the Looneys were entitled to $5,000 for repairs to their roof is not supported by the evidence. In this case, based on the evidence that was presented to the jury, they had two options if they found that there was, in fact, covered damage to the roof. First, the covered damage could not be restored or repaired without replacing the entire roof. This was the Looneys' primary position, in fact, only position. And second, that the covered damage could be restored with a smaller spot repair, which was identified by Citizens expert Mr. Wynn, rather than the full roof replacement.
Counsel, let me ask you this question. I think this dispute, at least to me, kind of turns on this verdict form and the fact that the jury wrote 4 repairs after the $5,000 figure. There was space on the form for them to put in the dollar amount. They did that, but they added this 4 repairs notation. If that 4 repairs notation was not there, they had simply just said $5,000, would this verdict be excessive or would it be inadequate?
Your Honor, it would still be excessive, and that's because the evidence showed that it would cost at least almost $9,700 for the actual cash value at the date of loss. That was the smallest number presented for replacing the entire roof. And there was no evidence presented at trial that the roof could be half replaced. So the mere award of $5,000 shows that the jury disagreed with the Looneys' position that the entire roof needed to be replaced.
But I also look at that number of $5,000 and see that it's about $4,500 more than the highest repair cost that the evidence supported. And it's about $4,500 less than the lowest replacement cost that the evidence supported. And so my point in asking whether it was excessive or inadequate is, how could we look at that and know necessarily one way or the other whether it was excessive or inadequate? If we grant you that it's not supported by the evidence of the 2 buckets as you positioned it, which makes a lot of sense, if it's right in the middle, how can we say it's excessive or it's inadequate? Either one.
Well, Your Honor, as you pointed out, one of the primary things is that the jury, they didn't have to, but they specifically wrote 4 repairs. And at one point during deliberations, they sent a question back out asking for Citizens expert Mr. Green's assessment on the cost estimate, but there was no physical estimate to give. The judge instructed the jury to just rely on their memory and their notes of the testimony that was given. And he was the person who was the only one who gave a cost of repair estimate other than replacing the entire roof. And here, as the 4th DCA stated in United versus Cologne, the plaintiff has the burden to prove a specific and definite amount of economic damages. And in fact, the jury was instructed in this case that the plaintiff had the burden to prove both the method and the cost of repairs. And so simply put, not only does common sense instruct us that if all parties agree that $9,700 is the cheapest you can replace the entire roof, any amount less than that means the jury did not think that the entire roof needed to be replaced, in addition to them writing the 4 repairs. But it also means that they have to rely on the evidence. And in this case, there was no evidence that you could replace half a roof.
Isn't there testimony from was it James, I guess the Looney's expert, even though he gave testimony about replacing the roof, I think his company provided 3 different estimates. But at the beginning of his testimony, he says, "I'm here to testify about the cost to repair." So how do we know that when the jury writes 4 repairs, that they necessarily mean some kind of spot repair or less than replacement, as opposed to repair in a more general sense, meaning replace the whole roof. In other words, if they blew the dollar amount so drastically, how can we then conclude that they were really clear about the distinction between a spot repair and a replacement?
Well, Your Honor, to not give context to the word repairs, if repairs meant anything they could possibly do to the roof, then there'd really be no point in the jury writing anything at all. There'd be nothing to distinguish. Any dollar amount they award.
Which leads to the question, the case law that suggests when the jury writes something that they're not asked to write, we just treat it as surplusage. Because the verdict form here didn't ask them to say whether you want to award damages for repair or replacement. It just said, how much are you giving them? Why wouldn't we just treat that for repair statement as surplusage and disregard it?
Your Honor, we shouldn't disregard it because this court is allowed to to alter a verdict to conform with their intent. So this is evidence of the intent, but even without the word for repairs, the $5,000, as I said, is just not indicative that the roof needed to be replaced. And the jury is not entitled to speculate or provide guesswork. Their job is to, especially in the case of economic damages, to award an amount that is consistent with the evidence. And there was, again, no evidence that half of the roof could be replaced. And it's clear, I believe, that they did not find roof replacement. So since they did not find roof replacement, then it must revert to whatever the maximum amount in evidence for something else was. And in this case, that was the spot repair identified by Mr. Nguyen, which Mr. Green identified would cost a minimum of $500. And again, this is the plaintiff's burden to prove both the method and the cost of repairs. And
That's interesting because, like, our last two cases, we did textual analysis of a statute and then I'm sure scintillating textual analysis of an insurance contract. This is just 6 people's driver's licenses, right? They write 4 repairs in there. You and I might sit here and think that we know what they mean. But in terms of following up to Judge Ganem's question, you've got the expert themselves referring to repairs and replacement interchangeably. There's an instance in the closing argument where that's done the same. How do we know what the jurors meant by 4 repairs if there was never an effort to ask them what they meant? They're not legislators. They're not contractual draftsmen. They're just 6 people sitting there doing the best they can. How do we know what they meant by 4 repairs?
Your Honor, in this case, I think we have to look at the totality and use common sense because, like I said, if you treat the word repairs as meaning anything done to the roof, then there'd be absolutely no meaning to writing.
What if I get together 6 fifth graders and ask them what the numbers after 5 are? Are they going to say the exact same thing that 6 70-year-olds would say about it in exactly the same cadence? What if I ask a bunch of high schoolers what they mean by, it's been a minute since I've seen you? Do they mean 60 seconds or do they mean a much longer period of time? This is what I'm driving at. I think you're probably right that 4 repairs means 4 repairs, but if we don't know, and we've got this case law that suggests that we just disregard it because they weren't specifically asked to do it, where does that leave you?
Well, Your Honor, like I said, I think it still leaves us with an excessive verdict because you can't replace half a roof. Common sense dictates, again, that the jury, if they thought the roof needed to be replaced in its entirety, would have awarded at least $9,700. Both parties submitted cost estimates on the cost of repair. So in total, there were 6 numbers ranging from almost $9,700 to almost $25,000. So
Counsel, can't we also just say if the jury had really wanted to make an award for repairs, they certainly wouldn't have awarded more than $500 because that's all that the evidence supported for repairs?
Not necessarily, Your Honor, but in this case, if they did want to make an award for repairs, and I do believe it's clear that they did not believe that the entire roof needed to be replaced, then the only default that they have is to go back to what the evidence presented. And again, the plaintiff was very adamant that the entire roof needed to be replaced. And this was a strategic decision by them. They could have very easily did what Citizens did. Citizens maintained from opening statements through trial all the way through closing statement that there was no cover damage whatsoever. But they still had their experts opine on a smaller possible single shingle or single shingle tabs worth of damage that could have possibly been by wind damage in case the jury didn't want to award nothing. And then they also presented their own cost estimates for an entire roof replacement so they weren't left with those numbers. In this case, the loonies could have very easily done something other than be adamant that the entire roof could have been replaced. They could have provided their own alternative to repairs for the small spot repair identified by Mr. Nguyen. They did not even cross-examine Mr. Green's $500 amount when he said a minimum of $500 to figure out what the maximum of that could have been. They also...
Can I go back to Judge Ganem's first question to start this away? I thought it was an especially good one because, and it follows up with how my last line of inquiry went. If we drop the words "for repairs" out of that verdict form, and I know you don't want to, but just assume for me the sake that it's not there, and it's sitting there dead in the middle of 500 and 9,500, isn't additor every bit as important as possible as remitter? And if so, then how is it an abuse of discretion not to give remitter?
Your Honor, I don't believe that it's every bit as possible as remitter in this case. And again, it's falling back on this principle that you can't replace half a roof, but you can theoretically repair a much larger portion of the roof than the small spot repair identified by Mr.
Let me give
Nguyen.
you an example about how it might not be. What if you had some jurors in there that just said, you know, the lowest estimate on that is 9,500, but I got a cousin who could do it for 5,000. And I know I'm not supposed to entertain this particular evidence and all that sort of stuff, but you know, those experts seemed a little bit sketchy to me. So let's just do 5,000. Or what if the verdict is a reflection of compromise among those six people, some of whom who want to repair and some of whom want to replace? That would seem to me to be the basis for a motion for new trial based on lack of competent substantial evidence for damages, but perhaps it's not suited for a discretionary review of remitter or additor. Do you see where I'm going with this?
Yes, Your Honor, I see where you're going with this. However, again, our position is still that based on the evidence, and again, you know, we've done a lot of theoretical talking about the words "for repair" not being there, but going back to your early example about how different things mean different things for different people, in all of those instances, though they may mean something different, everybody's meaning means something. To assign the word repairs meaning everything, and for them to make that distinction on the jury form means that they meant something by repairs. And if they meant whatever you do to the roof is a repair, then it doesn't mean anything at all. It would be assigning no meaning to their additional language. And again, I think it's far more likely that they, you know, maybe they misremembered the numbers for repairs. Perhaps they were trying to split the baby. I'm not sure, but most likely they're trying to award something for repairs more than what the estimate showed. And again, they didn't have the benefit of Mr. Green's estimate back there with them. You know, there's really only 1-0 difference between what he said and what they ended up awarding. But ultimately, again, this really just comes down to the evidence that was presented in this case. And again, it was the plaintiff's burden for method and cost of repairs. And if they wanted the jury to be able to award $5,000, you know, Mr. Funderburk, for example, said at one point that 58% of the roof was damaged. Even though he was adamant it had to be fully replaced, they could have, just as Citizens did, alternatively mentioned some sort of cost for a repair to 58% of the roof while still maintaining that it couldn't be done, and perhaps that could have come out to something like $5,000. But instead, they put all of their eggs in this one basket of replacement. So when the jury doesn't find that it has to be replaced, it necessarily has to revert back to what the evidence showed. And in this case, that was $500. And unless you have any further questions, I'll go ahead and reserve the rest of my time for rebuttal. I ask that this court grant remitter to $500. Thank you.
Thank you, counsel.
Good morning, Your Honors. Can you hear me clearly?
Yes.
Okay. My name is Matthew Mullinax, and I represent the appellees, Mr. and Mrs. Looney. By way of background, I was also the trial counsel and have represented them from inception through today. Now, with that, Your Honors, one thing I wanted to say, well, as I'm here, what we're asking the court to do is essentially to affirm the trial court's denial of Citizens' motion for remitter and then uphold the jury's verdict of $5,000 in covered damage.
Counsel, do you agree that the number 5,000 is not supported by any of the evidence in this case?
I would disagree, Your Honor.
And why? How can you get there reasonably based on the evidence that was before the trial court?
There are multiple ways, and that's part of the reason why I believe it would be improper to speculate as to what the jury might have thought. So one way, I'll say the defendant's expert on damages, Mr. Alan Green, said, and this sentence is important, so I'll read it. His only testimony as to the cost of repairs, it's one sentence, it's 12 words. It would probably be minimum charge for most roofers of about $500. So 12 words, 4 of them are qualifiers, probably, minimum, most, about. So even he is not specific, and he basically sets the floor at what a repair could be. Now with that, we have $5,000. It's clearly a 10x multiple of 500. So Mr. Funderburk, which was plaintiff's causation, so my client's causation expert, testified that there were 24 damaged shingles at the time of his inspection, 36 at the time of trial. Defendant's causation expert, Mr. Wynn, both of them were engineers, he testified there was 1 wind damaged shingle on the roof. So despite citizens saying no coverage, no covered peril, their expert said 1 wind damaged shingle. If the jury were to have determined, they also had photographs and evidence that 10 different shingles on areas of the roof were damaged, it would be very easy or plausible for them to say $500 for a repair. Citizen says it's 1. We believe there's 10 areas that need to be repaired. That's $5,000. I can give one other possible explanation.
Please.
Citizens damages expert also testified as to the cost to replace a square of a roof. So by way of background, roofers commonly refer to a square as a 10 by 10 section. And I don't think that that's in dispute under any of the experts here. That would be 100 square feet of the roof. So when you're speaking about a roof that's say 3,400 square feet, you would say it's 34 squares. Mr. Green, citizens damages expert, testified it would be $500 to replace 1 square of the roof. He used that math to say, this is how I came to my cost to replace the entire roof, 34.4 squares times $500. So with that, if the jury were to have determined that 10 squares, so 1,000 square feet of the roof, which is approximately 1/3 of the roof, needed to be repaired, it could have very easily said $500 a square, $5,000. That would also match with Mr. Funderburk's testimony that 24 to 36 different shingles were damaged. And I believe he said that was 7 slopes of the roof. So a slope being, you have all different angles. And his testimony was that in order to properly repair 1 damaged shingle, because of the brittleness and the age, you would have to take it up to the ridge, which citizens expert also testified. In order to properly do that, you'd have to take it up to the ridge. So it's potential that the jury determined, okay, we're going to do 10 squares times $500.
So is it your argument that regardless of whether or not they wrote this 4 repairs notation, if they had just simply returned a verdict form that said $5,000, it's your position that's supportable, but that's reasonably supported by the evidence in the case?
Correct. I don't believe that it's contrary to the manifest weight of the evidence. It's squarely within the numbers that were presented, roughly 8 total, I believe, actual numbers. And it's actually closer to the $0 amount that citizens have requested in this case. If I can make one try. Okay. I didn't want to interrupt if you had a follow-up question. So with that, there's been much position by citizens to say that the jury made a determination that repairs were the proper method or that the repairs needed to be made. I would present to the court that the jury was never tasked with determining whether to repair or replace, and they were not tasked with determining the method of repair of this roof. They were simply tasked with determining the amount.
What are the instruction? I believe the language that the judge used was you have to decide, how much to repair or restore.
Correct. And I have that.
Can we not interpret that as asking the juror the question that they perhaps answered by writing, for repairs, where they could have written, some other number to restore, but they picked this number for repair?
Yes, Your Honor. So that jury instruction asked them to, and I believe this is a quote, consider only the reasonable cost of repairing or restoring, and I would end quote. And then the verdict form did not ask repair or restore or replace. It simply said, what is the amount of covered damages? And so with that, Your Honor, I don't believe that the jury, 1, was tasked, but 2, would have been aware that they were deciding the proper method to repair this roof. I believe that it was simply presented to them, what is the cost to do that? And so when we hear, and in the briefs are heavily disputing whether it was a repair or a replacement, the fact that the jury was never given the word replace, it was simply repair or restore. You now have a third word that's put in the mix. And I do believe that the lay people, the term repair of a roof might commonly be interchanged with replacing the roof. Okay. So with that, Your Honor, I did address the different numbers that were presented to the jury. Ultimately, there were 6 different numbers for a full roof replacement. 4 of them were from plaintiff's damages expert. 2 of them were for Mr. James. 2 of them were from Mr. Green, citizens damages expert. And the reason for that is the jury was given 2020 numbers at the time of the loss, 2024 numbers at the time of trial, and then plaintiff's expert, Mr. James, also delineated into actual cash value and replacement cost value. So he had factored in depreciation. Then with that, the jury could have also taken the total replacement values, divided it by the number of square feet or the number of squares, and come up with their own assessment of what a 1 square replacement of the roof might have been. So again, I point that out to say that there were enough numbers presented to the jury that it is very difficult for us to determine how they came to that number. But it is definitely something that a reasonable person could come to by more than one method. The amount is not excessive. It does not put the loonies in a better position than they would have been had this contract been performed. Most of the cases cited to by defendant dealt with cases that were far in excess of the amounts both sought by plaintiffs and calculable by the evidence that was presented. Here we have a number that's actually less than what the plaintiffs sought and can be calculated by the evidence that was presented. As to abuse of discretion, I don't believe that that standard has been met in this matter. I believe that the trial court, the trial judge was present, heard the evidence, considered this on the motion for remitter, and with that, there should be broad discretion given to that judge. And as we look at this, I would say that it neither shocks the judicial conscience, the amount that was presented, nor does it manifestly contradict the evidence that was presented. If you bear with me, I just want to go through my notes and make sure I've hit my points. As to that verdict form, one other consideration, the policy has a deductible. It's a $1,000 deductible. That question was not posed on the verdict form. The jury was provided with the policy and evidence. So I bring that up because we are heavily considering how they arrived at $5,000. We don't know if they determined it was $6,000 and then applied that policy deductible. Preferably, you would have a verdict form that delineates how the jury arrived at their numbers. You could ask them replacement cost value, actual cash value. You could say with or without deductible. I think in the best case scenario, in a first party dispute like this, you would say, what is the replacement cost? What is the actual cost with or without deductible? And you tell the jury whether or not to apply that deductible. So as it sits here, we can presume that they determined 5,000 was the top end, but we don't know whether they actually determined 6,000 with that deductible. And then I would point that out as well, that with this verdict form, defendant could have sought more clarification. They could have sought for the jury to determine repair or replace. They could have sought those different numbers. The fourth question, I believe, on the verdict form. So in the jury coming to its determination, citizen's position is that no liability existed and that the jury should therefore not even come to a determination on amount. Had the jury determined citizens was correct, they would not have made it to the last question on amount. By determining that coverage existed, they made it to the last question. They gave that amount. So with this policy, there were 2 main defenses citizens presented: pre-existing damage, wear and tear, and some other issues. The difference being pre-existing damage, had any portion of the damage been the result of pre-existing damage, the language of this policy says that even if you have covered damage, it's all excluded. The jury determined that didn't occur. The second or the fourth question, but the one directly before the jury answered the amount, asked if there was any wear and tear. Now, the distinction with this is it asks the jury, was the damage caused solely by wear and tear? The difference there is the jury could have determined that some or a lot of this damage was wear and tear. sum was wind, and it would still be a covered peril. That also allows for the jury to have potentially determined that the roof needed to be replaced, but that a large portion of the roof was damaged due to wear and tear or an excluded peril, and that $5,000 was attributable to wind. I believe those were all the points I was going to make, unless your honors have any other questions.
Final question. If at the time that the verdict was delivered, if citizens believed that there was a discrepancy between the 5,000 number and the notation for repairs, did citizens have any recourse at that moment, or even a duty at that moment, to say something to the trial judge to attempt to get clarification from the jury about what they meant by that? Or would that have been improper at that point in time to go down that road?
I believe that you can always ask. If you have, then you have the benefit of the decision that the trial court made, and we would know whether that did or didn't happen. If you don't ask, and I say this as a trial litigant, it's hard to say later on that something should have been done because you didn't preserve that. So I do believe it was well within their ability. I think they could have. And I know in reading some of the cases that deal with abuse of discretion, one was the Ernie Hare Ford case, and the other was, I think, Brown versus the state of Stuckey. Those dealt with interviews of jurors after these awards were given. I know one of them even dealt with the jury came back with two different numbers. So there was essentially two counts, and it was very clear from the numbers that they had transposed them. So one was to the penny what one count was asking, and the other, like 11,192. The other one was 147,000. Even the judge said, we don't want to tell the jury what to think, but it appears as though you may have transposed these. Do you want to go back in the room and deliberate? Jury did. They came back out, but the problem was the total came to the same, but then they had two new numbers that you couldn't tell what they were. So at that point, the judge said, look, this is not so clear that I can tell them it was wrong or do anything. I think we have to let it sit. So I bring that up because I do think there's a vehicle where if one side thinks there's an error, there was an inaccuracy, there was confusion, this is against the manifest weight of the evidence. We don't know how they ever came to this. You could ask the judge to inquire to the jurors to some extent and see what happens there. I would also say, just from a more practical matter, it is not uncommon at all in cases like these to have, especially when you have a denied and you have a case where one side saying 0, one side saying this is our estimate, to have a number that comes in the middle. I've seen occasionally where the numbers go outside of it, but more often than not, in a first party breach of contract case, the jury is going to give some number that's between the two numbers.
Thank you, counsel.
Your Honor, just a couple points on rebuttal, starting with one of the last. It's not before this court whether citizens had the ability to ask what the jury intended by the $5,000, but there's certainly no preservation issue about their ability to still seek remittitor after the fact, remittitors for exactly these situations where we do not have an inconsistent verdict. An inconsistent verdict would be where they're mutually exclusive findings on the jury form. Something's obviously wrong. When that's not the case, you can always challenge for an excessive verdict by filing a motion for remittitor after the jury has already been discharged. And then at one point, he also said that it doesn't matter that the jury wasn't explicit, or excuse me, he said, talked about it, the jury not being explicitly asked repair or replacement, but that is a threshold question that's necessary to the jury's determination because they have to have a finding based on the evidence. In our briefing, we relied on the Apont versus Exotic Pools case. There's a fourth DCA case where the contractor was hired to build a pool deck, a screened enclosure, and after the project was completed, there was a drainage issue which was discovered. And at trial, the plaintiff's position was the entire pool deck needs to be redone, replaced. It's going to cost $38,250. And the defendant's position was, well, we can resolve the drainage issue by installing a commercial drain for $1,500. And in that case, the trial court awarded $9,000 and the fourth DCA remanded because it had to fall under something that was supported by the evidence. It either had to be $1,500 or it had to be $38,250. And in this case, we have the range at the top, almost $9,700 to almost $25,000, or 500. The evidence doesn't support anything in between. Now, I know.
Counsel, you talked about strategic decisions earlier, but I think citizens in this case made a strategic decision not to seek a new trial based on the verdict being against the manifest weight of the evidence, but to only ask for remittitor. Aponte, or aponte, however you say it, that would help you in the case of, like, we just want a new trial on damages because this number 5,000 right in the middle of the two buckets doesn't work. It's not supported by either range of the evidence. But in this case, you only asked for remittitor, and I believe Judge Traber asked about this earlier. That puts the trial court in an interesting position. If asked to give a new trial for damages, maybe it would be an abuse of discretion under Aponte for the trial court not to have done that here. But since you only asked for remittitor, we only have to say, well, is there any reasonable judge that could have said no to remittitor on these facts? And then the abuse of discretion standard is satisfied.
That's correct, Your Honor. We're here on the motion for remittitor rather than a motion for new trial, and the discretion, it is an abuse of discretion standard. However, like I said, the evidence still does not support $5,000, and our position is it's clear that.
Can I ask you about that? Because your colleague made an interesting point that I hadn't considered about the price per square. Could a reasonable jury have taken that mathematical calculation coupled with the testimony about the damages to the roof in terms of what percentage of the roof that it covered and come to that particular conclusion? We don't know what they meant about the deductible or not. It wasn't asked. But if you're in that 5,000 to 6,000 range, and you're in that price per square, does that provide competent substantial evidence to support the determination?
No, Your Honor, it doesn't, because there was no evidence or testimony at trial that you could extrapolate those numbers in that manner. In fact, the only brief discussion on any method of repairing the roof somewhere between the spot replacement identified by citizens experts and the full replacement was Mr. Wynn, citizens expert, briefly discussing how a repair in a different part of the roof would change the calculus essentially of what the repair entailed. So in this case, especially since we don't know where the additional tiles identified by Mr. Funderbrook exactly are, and whether those and even if we did, whether those are in locations of the roof that require different kinds of repairs than simply maybe peeling off one shingle tab and replacing a shingle tab for the price of the shingle tab at $500. Because we don't have any of that information, it would require the jury to participate in speculation and guesswork in order to come to some sort of a conclusion about what it would look like to repair some other unidentified portion of the roof. And again, it is the Looney's burden in this case to prove, as the jury was instructed, both the method and the cost of repair. And so again, if they wanted the jury to be able to extrapolate out some larger amount of repairs, then they needed to give the jury the tools to do so. Citizens didn't give the tools to do in this case, and the Looney's didn't either. Therefore, the jury would be incapable of coming to this calculation by themselves. And I know he mentioned this idea of the wear and tear portion. However, the instruction was just that it's excluded if it's entirely based on wear and tear. The jury was not then instructed that if it's not excluded, then do your best to figure out how much was wear and tear and how much was attributable to the cover damage, and then assign some portion of this to the total and some portion to the wear and tear. They're restricted by what was presented. And again, what was presented was either $500 for this cost of repairing the small spot repair, the only thing we know the method and cost of repairing on that roof, or replacing the whole thing for somewhere between $9,700 and $25,000. And for these reasons, Citizens is entitled to remittitor in the amount of $500, and we respectfully request that this court reverse and remand. Thank you.
Thank you, counsel. All right, we will be in recess. Thank you.